Hello, Judge Shapiro. At last. Can you hear me? I guess not.
Hi, Judge Shapiro. Are you able to see me?
One moment. I'm still trying to figure this thing out here. This really frustrating. Can you hear me?
Yes, I can.
All right. Well, I opened the background thing so I could blur my background, and now I can't get the options for backgrounds off my screen.
Do you see an X? You might have to.
That I could figure out. Let's see here what I got going. I don't know. Jeez. And I have nothing to click on to see you. I don't know.
Okay. Is it?
Okay. Now that's better. Hold on. I think I figured something out. Thank you for waiting. Okay. I'm good now, I guess. Huh? You can hear me. You can see me.
Yep. And you're able to hear and see me?
I can. Is everybody here?
There is no one here just yet. So I'm going to put the screen back up. And then once they get here, I'll let you know.
Thanks a lot. Okay.
Yep. Judge Shapiro, we have all the parties here if you're ready.
Here we go. Yes, I'm ready. Hello?
Yep, I'm bringing them in now.
Great, thank you.
Morning, Your Honor.
Morning, Mr. Fish. And Mr. Martin, Mr. Martin, you're here for the plaintiff, right?
I am, Your Honor. Thank you. Yes, John Martin, on behalf of the plaintiff.
Okay. And is it Frogner? Am I saying that right?
Yes,
Are you
I'm the court reporter.
Great, finally. And then Mr. DeVore, you are?
Morning, Judge Shapiro. I represent one of the plaintiffs as well.
Okay, all right, very well. We don't have anyone here representing Ms. Gaspar. Is that right?
That's correct, Your Honor. And on that note, Judge, if I may, we
Yes.
did send a courtesy copy of the motion as well as the notice of hearing to Ms. Gaspar's counsel. We haven't heard anything from her since.
Could you just submit something for the file to indicate that?
Yes, Your Honor, we will.
Thank you. All righty, so I'm going to call the case. Court reporter, you're all set?
Yes.
All right, very good. So this is a Court of Claims matter, docket 23-7, Joshua Edwards et al. Versus State of Michigan. I believe this is a wrongful imprisonment case, and we are here on the plaintiff's motion to compel a further deposition of, I think, a police officer or a former police officer, I'm not sure, Sergeant Gaspar. So plaintiff, it's your motion. Why don't you begin?
Thank you, Your Honor. As we mentioned in our motion here, Judge, this arises out of a murder case wherein the plaintiffs in this case were found guilty of murder based on the testimony of one 15-year-old individual. This individual had provided 2 interviews to the former police officer, Sergeant Gaspar, from the Flint Police Department. And apparently she failed to turn over the recordings and merely put together a summary of the interviews as opposed to the transcript, at least on the first one. She did, however, offer up a copy of the transcript from her second interview. What we have here, Judge, is we had noticed up her deposition. And when we had originally noticed it up, we get a call the day before the deposition.
Before you continue, Mr. Martin, let me ask you, and maybe you're getting to it. Was this by subpoena or was the defense going to produce her?
This was by subpoena, Your Honor.
Okay, thank you.
Sure. And I apologize.
Yeah.
But in any event, we get a call from her counsel, Ms. McFarland, who says that she needs time to prepare, and she asked us for documents pertaining to the case. Apparently, Ms. Gaspar, the former police officer, did not have those documents. So he sent them over to her, re-noticed the dep. I believe it was about a month and a half out or 2 months out. And then the day before the deposition, we again get a call from Ms. Gaspar's attorney, who advises us that Ms. Gaspar will show up, but she's going to assert the Fifth Amendment. And so, in fact, they appear for the deposition. And from jump,
I read it.
Okay, I can skip through all that. So the point is here, Judge, I just wasn't sure how much you wanted from me. The point is here, Judge, she failed to answer any question. I mean, when we talk about a question about where did you go to school, she pleaded the fifth. So we go, as in you read the motion, you can see that there's a lot of innocuous questions, quite frankly, that have nothing to do with the case, where she asserts the privilege. And I think more importantly, Judge, getting to the nitty-gritty of the questions pertaining to the case, there's no threat of prosecution against Ms. Gaspar, because the only viable claim that we see that there would be against her might be for perjury. And of course, the statute of limitations is 6 years. So if you take it to the latest, and I think if I remember correctly, it was 2009. So that ship sailed. I mean, the 6-year statute of limitations is gone. There's nothing that keeps her from answering our questions.
All right, well, let me ask, what testimony could she give that's relevant to the question of whether or not your client can demonstrate his innocence?
Judge, she would be the person that withheld the evidence from us and from the prosecution.
But you have it now, don't you?
We do, but we need to know the how and why of of how it happened, that it wasn't provided to the prosecutor.
When you say the how and why, what do you mean?
Well, I mean, does she have a valid reason, according to her, why it wasn't turned over? I mean, I think that's important for us to know. While she's in,
Okay.
while she's on the hook, to use that phrase, whether she intended to do it or it was an innocent mistake, the fact is we still get to know just what it was. And quite frankly, if we take her testimony and she in fact does not tell the truth, I think that's important to get in the case settled too.
Okay, let's hear from defense counsel. Obviously not for Ms. Gaspar, but for the state.
Your Honor, I don't really have anything to add. We continue to concur in the relief sought in the motion. We're also interested in this witness's testimony, and we were also surprised by her decision to take the fifth throughout the deposition. And so we would concur in the motion to compel.
All right, Mr. DeVore, did you want to say something? I didn't give you a chance.
I appreciate that, Your Honor. I don't have anything further to add. It sounds like Your Honor has taken a look at the transcript, which is, reads as about the most surprising deposition transcript I've seen, I think. And I was there for the deposition.
I'm sure it was thrilling.
Yeah.
Really, my only concern is, well, two things. I really would like to hear from her attorney, because she may have something in mind other than perjury. I can't imagine what it is, but I'm hesitant to issue an order saying someone can't plead the Fifth Amendment when her counsel or she hasn't said anything to me or filed anything with me, despite the fact that perhaps was the motion served on them?
Yes, Your Honor, it was. And when I say served, it was a courtesy copy, of course, but we did that the day of that we sent this out. She's got a copy of the motion as well as the notice of hearing too.
Is there a reason that the courtesy copy can't be deemed, can't allow you to assign a proof of service so that we have that?
Sure, I don't see a problem with that at all. We can do that.
Okay. All right. So for some reason, her attorney hasn't appeared here today. Well, I'm sorry to perhaps disappoint, but I'm going to give her a second chance. I want an order under the 7-day rule, and I'd like her served. The counsel, whoever she is who appeared for Gaspar, so if she wants to jump in and say something, she has another shot. I'm also a little hesitant to grant, across the board. I mean, I don't have any problem with an order that says you got to answer all the preliminary, anything that doesn't go to a potential illegal action on your part, she's got to answer. But I remain concerned about issuing an order that says you have no Fifth Amendment privilege here.
Excuse me, Your Honor. Your Honor,
yeah.
I don't mean to cut you off. I was
Please.
just having a note by my assistant. Apparently, Ms. McFarland is logging in right now to our hearing.
Excellent. Okay.
That's
So
it.
let's all just wait a moment.
Sure.
Okay, I'm going to mute until somebody comes in.
Ms. Frogner, I'm not sure if you're in control of the Zoom call or not, but I also have my colleague, Ms. Casperson, who appeared for the state at the deposition, who I believe is also in the waiting room, and I don't know if we could possibly let her in as well.
Christy, if you're able to let them in, please go ahead.
I will let them in now.
Thank you.
Thank you.
Very good. All right. The record should reflect we've had two additional attorneys join this motion hearing. Alexandria Casperson, who was, I believe, is also a plaintiff's attorney or state. I can't recall. State?
For the state, Your Honor, yes.
All right. Sorry about that. And we have Ms. Lee. And my understanding, Ms. Lee, is that you represent Ms. Gaspar. Is that correct? And you have to unmute.
No, Your Honor. I represent plaintiff Sequan Hinton with Mr. DeWar.
Oh. So, Christy, is there another person waiting to come in who represents Ms. Gaspar?
If she's in the waiting room, her name is Shelley
Person.
McFarlane.
Yes, the Shelley McFarlane. She is trying to come in.
Okay. Well, we'll wait because she's the one we need.
I'm sorry to interrupt, but could I ask who you are appearing for, Ms. Lee? I heard the name, but I wasn't sure.
Yes, on behalf of plaintiff Sequan Hinton.
Sequan Hinton?
Yes,
C''Quan.
that's correct.
Thank you.
All right. So, Ms. McFarlane, thank you for appearing here today. You didn't hear the argument, but it was really quite brief and essentially restated what was in the brief. And I guess the questions I have for you, but of course you can say anything you want, is on what basis does your client refuse to answer general questions? And what is the potential criminal liability for which he's asserting the Fifth Amendment as to the, let's say, more substantive questions about the case? But you can tell me, just go ahead and give me your whole position.
Thank you, Your Honor, and thank you for allowing me to join here as well. As far as the Fifth Amendment right for my client, again, I know that in motion it stated that the only criminal offense that she was facing could potentially be perjury. With that being said, the statute of limitations, there was no mention as to whether or not it has expired. There was no mention as to any federal or state authority regarding whether or not it has told, or if there was any follow-up that would state that the statute of limitations has ended. As far as her asserting her Fifth Amendment right, again, it would be for any potential self-incrimination, which again, with perjury, that doesn't necessarily mean that it has expired.
Well, do you have reason to believe it hasn't? Can you hear me?
I'm sorry. You there? Okay.
Yes, can you hear me okay?
Yes. What was your question?
My question was, do you have any reason to believe that the perjury statute of limitations has not run? Or can you refer to any other potential criminal offense that concerns your client?
I don't know if it has expired. Again, I don't have any documentation or anything that says whether or not there was polling. I don't want to see something come down the road that'll say that it had not expired. There could potentially be state or federal charges. I haven't received anything, again, from state or federal saying that there wasn't any continuing accusations of conspiracy.
So it has to be conspiracy to do something, but I don't know how long the statute of limitations is on that charge. Okay, so before we push further on this, let's return to the issue of where were you trained? Where did you go to school? Where did you work? The general deposition questions that don't go necessarily to the issue of the interview, what was recorded and how she testified.
Okay, there were questions regarding her work and procedures, policies and procedures. And again, answering those questions now after such a long delay, I would want either the documentation from the department or have the documentation there in order for her to review. But to have her restate policies and procedures that were maybe at issue then versus now, again, I don't see that being pertinent or appropriate for her to answer now. She could.
Well, I'm sorry, you continue.
It could be, I mean, if she was to say something based off of memory now, it could be wrong. I'm sure are documentation that is provided or that they could get from the department directly to answer those questions regarding the policies and procedures of her previous employment.
Sure, and I understand that concern, but that doesn't seem to have anything to do with the Fifth Amendment. Those are reasonable objections at a deposition. You're asking my client about a policy that she last saw 6 years ago and you haven't produced it, et cetera, et cetera. But I don't see any basis to claim a Fifth Amendment privileges to that. Was there anything else in the general questions that particularly concerned you, or if you want to respond to what I just said as well?
I mean, again, just as far as answering those questions, I don't have any authority or the other attorneys have no authority to bind the state or federal for bringing new charges. So if she was, again, to answer those questions, it could set her up for new perjury charges.
Or you're concerned that she could be charged with perjury arising out of this case? Well, why would she perjure herself in this case? If she doesn't know something, she can simply say she doesn't know it. That's true of everybody, right? Okay. So I'm not quite sure. I'm sorry, Ms. McFarland. Before I go back to the other side, did you want to say something else? I keep cutting you off.
Yes, I'm sorry. With the state Supreme Court case, again, it was terrible. It was scathing. And so moving forward, really anything that she says could result in perjury or an additional charge following the Supreme Court statement and then moving forward.
Well, it's an interesting argument. And, it's not like I deal with this issue all the time, like almost never. But it's an interesting argument that I'm concerned I may commit a crime when I'm testifying, as opposed to I'm concerned I may give testimony that reveals a crime that I committed. Okay. Anything else, or shall I go back to Mr. Martin and Mr. Fish?
Just, again, even if she's telling the truth during a current deposition, that portion worries me too, because telling the truth could also set her up, again, based off of that Supreme Court.
I haven't read it, but I will.
Okay. Thank you.
Okay. Mr. Martin?
Yes, Your Honor. For one, just real quickly with respect to the perjury charge again. The statute of limitations is 6 years. The 6 years has in fact run. And as the court pointed out, with respect to the conspiracy concern, there has to be a conspiracy to do something. There's nothing. And I think with the argument she's making, I'm not sure that I follow. But if she's suggesting that if her client testifies and tells the truth, there's still a chance they could bring charges against her. I don't know how that works. That just doesn't seem possible to me.
Okay. Mr. Fish?
Your Honor, one way we could possibly go about this, since we already have the 3 hours of transcripts with all the questions that were to be asked, is to have Ms. Gaspar identify the specific questions of which she has a good faith claim of the Fifth Amendment. And then we could look at those questions more specifically, and that would winnow out some of these general background questions. Looking at the Morgan Roth case that plaintiff's counsel cited, they discussed the plaintiff having the burden of making an initial showing, or not the plaintiff, I'm sorry, the person.
The claimant for
testifying,
the
correct.
yeah.
Having the initial burden of making a good faith claim of the Fifth Amendment. And I think that would be helpful here moving forward, of knowing what crimes are we concerned with here and what specific questions are we concerned with.
All right. Either Ms. McFarlane or Mr. Martin have any response to that suggestion?
This is John Martin, Judge. The only comment that I would add to that, we could either go that route, or as they did in Morgan Roth, obtain an affidavit from Ms. Gaspar explaining, how she thinks this could negatively affect her. But either way, I'm good with it. So,
okay, Ms. McFarlane, is that agreeable to you? I understand you'd like to, and you certainly can, for the record, if you want to continue to object to the questions I've already indicated I'm going to allow. But you might want to, as a second tier, tell us which ones you think are the core, and then I'll review that quickly. And Mr. Fish, you suggested this. I mean, I'm satisfied if she just gives me if we just get an identification of the relevant questions. But if people want to respond or write something about it, I'll let you, but I don't think I need it. You probably just want an order. Yes. But Mr. Fish, what do you think? You think you might want to say something in response to the identified questions? Well, let's do
all
this.
Attorneys, Your Honor. I think we probably will have something to say, but I think our concern is
I'll
just
look at
this
it.
case moving along.
Yeah, I'll look at it. If I have questions, I'll request, very short briefs in very quick time, because I don't want to hold it up any longer. Okay, Ms. McFarlane, can you do this in 7 days? Because I know you might have to talk to your client.
Yes, Your Honor.
Very good. All right. So today is September 25. I'll note that by October 2, Ms. Gaspar is to file in whatever form suits Ms. McFarlane an identification of those questions to which she specifically objects as potentially incriminating, even though she has preserved her objection to all the questions. Make sense? I hope. Okay. Anything else I can do? Okay, and I will put that at the front of the burner and look at it as soon as it comes in. Okay. Thank you all for appearing today.
Thank you, Your Honor.
I will see you next time we deal with this case. All right.
Thank
Thank you, Your Honor.